frequently when the United States engages in military force, there's a whole conversation about the legality of that, whether it's a war crime or whether it's the crime of aggression or whether it's been duly authorized by Congress. And I want to kind of run through some of that, and I'm kind of lumping it under this heading of the War Powers Resolution because we're going to talk quite a bit about what that is, and some of the politics around it. But I also want to sort of keep this conversation larger around what is war and some of the relevant legal structures, both internationally and then within the United States, that might be relevant for thinking about the authorization of the use of force. So thinking about just what do we mean when we talk about war, certainly when we're talking about the legality of war in the United States, people oftentimes will point to whether something was a declared war. And so in the United States context, Congress has the power to declare war. But that's a legal state of affairs. It doesn't actually describe the conditions on the ground. You can have a declaration of war that doesn't actually result in any sort of military action. Likewise, you can have military actions that aren't declared wars. That's actually the more common state of affairs. So social scientists don't rely upon those legal definitions and those legal declarations. Instead, we look at sort of the conditions on the ground. And so we typically will point to wars if there are a conflict, a military conflict between two sovereign states. And we also look at the scale of the violence, right? So if you have 1,000 fatalities, typically battlefield deaths, I should say, we would say that that's a war between, an interstate war between two countries. Social scientists will also track these things called militarized interstate disputes, which are more one-off. It could be the threat of force, or it could be the use of force, like dropping a bomb or launching a missile, but it's typically a one-off kind of a thing that we track and try to study. But again, doesn't fit this idea of war, which implies sort of an ongoing process, which implies a large scale. Shifting into the conversation about the legality of this, oftentimes when military force is used, people will rhetorically say, well, that's illegal. One of the ways in which it might be thought of as illegal is under international law. And so under international law, it's well established historically and in customary international law, and then codified in the UN Charter, that all states have the right to self-defense, right? If you are attacked, you can respond with military force, and that's permissible. But if you are the one initiating that, you may be committing the crime of aggression, which is something that exists and has existed for a long time under customary international law. We didn't have it written down and defined in a concrete way for a long time, but we sort of understood that if you are the one initiating military action, that you're doing something inappropriate under international law. The Rome Statute, or I should say an annex to the Rome Statute, actually attempts to codify this. And so I just kind of want to briefly run through some of the things that are picked up in that codification of the idea of aggression, or the crime of aggression. So it could be an invasion, it could be bombardment, it could be a blockade, it could be an attack on the armed forces of another state somewhere else. You could be using the armed forces that are stationed within a country in a way that maybe wasn't authorized, so exceeding their mandate. It could be using your territory as a staging ground for somebody else, or it could be using irregular forces to engage in military action against another state. So there's lots of components for what we mean by the crime of aggression, but I'll note that some of those are not necessarily what we mean when we talk about war. Some of those might fit the definition of MIDs, or militarized interstate disputes. It could be a one-off and still satisfy that condition of the crime of aggression. Pivoting to the domestic context, the U.S. Constitution lays out broad powers related to the use of military force and the conduct of war to Congress under Article 1, Section 8. And so that includes things like the ability to borrow money. In the lead up to World War I, the United States established the debt ceiling as a legal mechanism to authorize or to facilitate the borrowing of money to support war efforts. Congress certainly has the power to declare war, to grant letters of marque and reprisal. They can set up rules governing the capture of land. They can also fund the military and establish bases and other defensive structures as part of their remit under Section 8 of the U.S. Constitution in Article 1. The president's powers are far more limited in that the only real power is the president shall be commander-in-chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. That's pretty much it in terms of what the Constitution says about the power of the president, sort of the person in charge of the military, and that suggests or implies that the president will be faithfully executing what Congress does, and that there will be some sort of formal declaration of war. But in practice, when presidents have used military force, when they've exercised that role as commander in chief and also chief diplomat in conducting foreign policy for the United States, they've relied on a wide range of different types of justifications and authorizations that have supported that, right? So one way that this is played out is that Congress has not supplied a legal authorization or a legal support for military operations, but instead has just provided the cash for it. That there's an operations budget and there's an understanding that somebody will be bombed in the coming year to the tune of $100 billion. We don't know who, but the president has been granted the money to make that happen. I'm being a little bit cavalier about this, but when the United States has been engaged in ongoing operations during the Cold War, during the Global War on Terror, and then in the 19th century during the Indian Wars against Native American tribes, sometimes those actions didn't necessarily correspond to a direct authorization from Congress, but there was money available to make those things happen. Sometimes there is an implicit authorization from Congress, and so if Congress passes a law, setting up a structure to organize westward expansion and establish forts and provide for security, implicit in that is the securing of the frontier may mean conducting war against Native American tribes. That is not formally authorized or declared, but is sort of an implicit implication of we're going to do this other thing, and this is the natural consequence of that. Sometimes Congress will explicitly authorize military force and do so without a formal declaration of war. So the Global War on Terror is an example of this, where Congress passes a broad authorization for the United States to go after Al-Qaeda and related entities, and does so not as a declaration of war, but as basically giving a mandate and permission to the president to conduct these operations over an extended period of time and over a broad scope. Similarly, the Vietnam War was facilitated through an authorization, the Tonkin Gulf Resolution, that wasn't a declaration of war, but gave to the president authority to expand operations against North Vietnam and support South Vietnam. Sometimes you do get a formal declaration of war. The United States has declared war, I believe, roughly 5 times. War of 1812, Spanish-American War, Mexican-American War, World War I and World War II, and I think in both of those there were multiple declarations against different countries, but it was the conflict. There were essentially 5 conflicts where Congress has formally used its power to declare war. Sometimes that declaration comes that action, that authorization comes in the form of treaty commitments that the United States has signed on, and Congress has ratified treaties. So if NATO takes military action under Article 5 of its charter, a president could go to Congress and say, I don't actually need additional authorization. This was implied when you ratified the NATO charter. We're already signed on and I already have the authorization I need. That line of reasoning was actually used by Harry Truman in the Korean War, where he didn't seek formal authorization from Congress because he said, I have the authorization I need because this is an operation that is green-lighted by the United Nations Security Council, and Congress has ratified the UN Charter and therefore implicitly has handed over a share of a potential path to authorizing military force to the United Nations. And then lastly, presidents may assert that they have the right to conduct military operations because of powers inherent in the presidency, that one line about the president being the commander-in-chief of the armed forces is sufficient justification for the president to do whatever he or she believes is necessary. This line of reasoning was put forward by the Bush administration following September 11th. It was a legal argument. It has not been fully tested, but the argument was essentially that if a president believes something is in the national interest, if it is necessary for the safety and security of the nation, then the president, in the role of commander-in-chief, can do whatever he or she chooses, as long as the president believes that it is necessary for the safety and security of the nation. That's probably overstated, but it points to something that we're going to see in the War Powers Resolution, this built-in tension between how presidents have understood their role as commander-in-chief and how that's bumped up against Congress over time. And so following the Vietnam War, where that Tonkin Gulf resolution spiraled into a decade-long conflict that I don't think members of Congress fully anticipated that's what they were signing on to, Congress sought to reestablish its role in authorizing and overseeing and controlling the conduct of warfare by the United States, and passed a joint resolution between the House and Senate, the War Powers Resolution. This was vetoed by President Nixon, who saw it as a curtailing of the executive in a way that was contrary to the Constitution. That veto was overridden by Congress, but there's been an ongoing tension between the executive branch and the legislative branch over the War Powers Resolution. Indeed, one of the requirements of the War Powers Resolution is that the president notifies Congress that military action is underway. And historically, and I'm not sure that this is still happening, and I'm not sure it might be splitting hairs, but oftentimes presidents would notify Congress consistent with the War Powers Resolution, saying, I am doing this thing in a way that would fulfill the requirements of the War Powers Resolution, not because of the War Powers Resolution, but just consistent with it, versus I am notifying you pursuant to, right, under the direction of or because of. So sort of that pushback of saying, this does not really bind me, but I'm playing ball because I'm being nice, and I'm not going to violate the terms of these instructions that you've given me, even though I reserve the right to do so if I felt it was necessary. And there's a couple things that are going on in the War Powers Resolution. So one of those is that if presidents initiate military action, they're supposed to notify Congress in a timely manner, 48 hours from the moment which this is happening, and there's a notification to the Speaker of the House and to the President pro tem of the Senate. There's also an expectation that before military actions are undertaken, that there will be a process of consultation. The members of Congress will be kept in the loop. What that consultation looks like is hard to know exactly. In theory, you would have briefings to congressional committees. They would know what is happening. Congress gets the national threat assessment, but oftentimes these decisions are still taken very closely by the executive branch, and Congress is oftentimes figuring things out sort of after the fact. So that consultation, I think, is oftentimes practiced at a higher level versus members of Congress are brought into the war room and help deliberate in decisions about what should happen. After a president has initiated military force, the War Powers Resolution gives the president 60 days of latitude in which he or she can continue to conduct operations without an authorization from Congress. And so what the War Powers Resolution essentially does is it gives the president a free hand to conduct military operations for 2 months if the president believes it is necessary and there's not yet a resolution that's been passed to support or oppose ongoing military operations. The president may extend that 60 days for another 30 days. So essentially you get 90 days potential of military operations without any authorization from Congress, other than that presidents are to continue providing updates in the case of ongoing military operations every 6 months. So if there is some sort of authorization, that would be an ongoing conversation. A lot of the War Powers Resolution actually is directed at Congress itself, and it provides instructions about how Congress will respond when notified. And there's an expectation that Congress will respond when notified, that it has a responsibility to assert itself in this moment. And so it talks about how this becomes the pressing business of the chamber when there's a resolution that's been put forward, and that it should be voted upon, right? So the idea is that Congress will give an up or down vote on a military operation, either authorizing it so that it can continue beyond that 60 or 30 day, additional 90 days total, beyond that window, or voting to say, no, this needs to stop, at which point presidents are to wind up operations in a timely manner. We'll talk about the politics of that, because while I think that makes sense in practice, right, that it's walking this fine line of Congress doesn't want to prevent the president from being able to do what is necessary for the security of the nation, but also wants to make sure that it is actively enrolled in that conversation, and that it has a say, and that it will have a say, and it will take action. That's an important part of it asserting its constitutional authority and its constitutional powers. There are some important carve-outs in the War Powers Resolution. In general, if the United States is attacked, the War Powers Resolution doesn't apply. More specifically, the War Powers Resolution doesn't apply if Congress is unable to meet, right? So if Washington, D.C. has been burdened by the British in the War of 1812 and Congress can't meet, can't convene to authorize additional authorizations, the president can continue to conduct war. If there's a nuclear strike on D.C. and Congress is obliterated, the president can continue to conduct war. They've sort of worked through that scenario. There's a carve-out for ongoing treaty commitments. So again, if NATO invokes Article 5 of its charter, the president could say, I don't need congressional authorization because this is covered under existing treaty commitments. And there's actually even a carve-out for that United Nations-led action, which is, I think, a little surprising given that when Truman put forward that argument in the Korean context, it was not well received at the time and viewed as perhaps skirting around what would have been a difficult political task of getting Congress to sign off on the Korean War. So we kind of understand now what the War Powers Resolution sort of says or demands of the president and of Congress, but I think it's important to also understand the politics of this. And I'll flag this in two ways. So one, I'll simply say, after World War II, the United States built a robust global system to support nuclear weapons, in particular to support the ability to launch nuclear weapons very rapidly on the president's order. And this is a necessary thing for a deterrence, for nuclear deterrence to work, that a president is able to authorize a launch, and that there's nothing that can be done to stop that. And so we've essentially created a system in which, on the word of the president, with no oversight or no review, the president can end life on Earth. That is a power the president has. That is a power that's been created by virtue of the nuclear arsenal. There's sort of the presumption that the president would not do so, but that is not a legal restriction. That's a good judgment restriction, we hope. When we're talking about non-nuclear conflict, presidents have, again, oftentimes asserted great latitude in the ability to conduct military affairs and push back on congressional oversight. But even when Congress does provide authorization, that authorization is makes for tricky politics. And so I'll just flag a couple different situations that I've noted that really put the lie to what this looks like in practice and why presidents have so much latitude. And so with the global war on terror, the United States, President Bush put forward a very broad request to Congress. And Congress responded by essentially giving the president the power to conduct military operations whenever and wherever he saw fit, as long as there was some connection back to the idea of terrorism and Al-Qaeda. It was a authorization with virtually no restrictions, which is just a sweeping sweeping sort of authorization, and it was roundly criticized as giving presidents too much power and Congress basically giving up its role of oversight of military operations. Now, there's still under the War Powers Act the requirement that Congress be kept in the loop and notified every 6 months about how things are going, and Congress still has to authorize spending year after year after year, but the president doesn't have to keep coming back and requesting additional authorizations because the conflict has moved to a new front or a new country. The authorization for military force to be used against Iraq in 2002 was framed in an interesting way. It was framed as necessary for the president to effectively conduct negotiations, that it was giving to the president the stick necessary to force Saddam Hussein to relinquish his weapons of mass destruction. The idea was that this is a negotiation tool, that we're giving to the president this power, not with the expectation that it will be used, but that it might be used or that it will provide leverage so that war can be avoided. That's an interesting interpretation of the War Powers Act, of not necessarily authorizing an action that is going to be taken, but again, handing to the president greater latitude and greater power. In 1999, the United States, as part of a NATO operation, began a bombing campaign against Serbia to help the Kosovo Liberation Army gain independence and stop an ethnic cleansing campaign that was going on. And the president notified Congress of this. That prompted the Senate, pursuant to the War Powers Act, to vote affirmatively to authorize the military action against Serbia. That resolution then went to the House, where it ended up in a tie. And since it wasn't an affirmative authorization, in theory, right, the president should have withdrawn military forces. Instead, the bombing campaign continued, and Congress continued to pay for it. They continued to authorize funds to allow that to happen, and didn't rebuke formally President Clinton for continuing the authorization. And I would suggest to you that this is perhaps the new state of affairs, and the Libyan intervention maybe even makes that more clear, where the United States initiates military operations against Libya. President Obama notifies Congress, and Congress doesn't schedule a vote, which they're required to under the War Powers Resolution. They don't. They continue to fund it. They continue to pay for it. They don't take any formal action to stop the intervention or to rebuke the president. But instead, they're in a situation where they're perhaps trying to have their cake and eat it too. That they don't want to be in a position where they are hamstringing the United States from taking military action. And they're not hamstringing a president from doing what he or she would feel is necessary, and thus leave themselves open to charges that they're working against the national interest. But they also don't want to be on the hook for having voted to support that particular military action, because if it goes badly, they want to be able to point to the president and say, we didn't support this, we didn't want this, you were off doing this thing on your own. Whereas if you get a authorization that goes through Congress is at least formally having said, we think this is something that is okay, or we support. And the conflict that occurred between President Obama and Congress plays out again in Syria, where President Obama is preparing for bombing of Syria, goes to Congress and says, I need a resolution. I need you to vote before I can take this step. And Congress votes no. And President Obama opts not to initiate a bombing campaign against Syria because of this standoff. But I think that this is sort of baked into the cake in executive legislative relations, that Congress doesn't really want to be in a situation where it is hurting the troops who are in a position of active hostilities but also doesn't want to be on the hook for having voted to support active hostilities in case things go horribly wrong. Anyway, at any rate, I wanted to kind of sketch out the broad strokes of the War Powers Resolution so that folks maybe have a greater sense about when military action is taken, the extent to which that is consistent with law, consistent with the Constitution, and what that legal justification might look like.